What if the selfie you posted 3 years ago, the comment you left on a friend's post in 2021, or the group you quietly joined and never posted in is right now sitting inside a federal database being cross referenced against your visa application? What if the thing standing between you and your green card, your student visa, your family reunion, is not your finances, not your paperwork, not your criminal record, but a single post you made on a Tuesday afternoon and completely forgot about? I need you to hear me clearly right now. Social media vetting in 2026 is not a rumor. It is not an overreach that is being challenged in court. It is fully operational, it is expanding, and people are losing visa approvals over it every single week. If you have a DS 160 or DS 260 pending, if you are preparing for a consular interview, if you cross the border with any regularity, or if you have any immigration benefit in process right now, stay with me for the next 14 minutes because what I am about to walk you through could be the difference between approval and a denial that follows you for life. Welcome to Immigration Path USA. This channel exists to be the clear, grounded, no panic voice in a space that is absolutely flooded with misinformation, incomplete advice, and content designed to scare you into clicking rather than actually helping you understand what is happening. We break down real policy, real procedures, and real consequences so that you can make informed decisions. And before we go one step further, I need to share our standard disclaimer with you. I am not an attorney. Nothing on this channel is legal advice. Everything you hear here is strictly for educational and informational purposes. Your immigration case is unique. Your digital history is unique. And before you make any decisions based on what we discussed today, please consult with a licensed immigration attorney or an accredited representative who can evaluate your specific situation. Now, let us get into what is actually happening. The social media vetting program did not appear overnight. It grew. It started with national security focused visa categories after 2017, expanded under successive administrations, and by 2026, it has become a standardized part of both consular processing and border inspection for a wide range of applicants. The two agencies you need to understand here are the Department of State, which oversees consular officers at U.S. embassies and consulates abroad, and Customs and Border Protection, which is the agency your application encounters the moment you arrive at a U.S. port of entry. Both agencies now have formal frameworks for reviewing social media as part of their vetting process, and both have the authority to use what they find to deny you entry or a visa benefit under existing provisions of the Immigration and Nationality Act. Here's exactly what is being asked of you and why it matters. When you fill out the DS 160, that is the non-immigrant visa application used for tourist visas, student visas, work visas, and others, and the DS 260, which is the immigrant visa application used in consular processing for green cards, you are now required to disclose your social media handles. The question asks for your usernames or handles on a list of specified platforms covering the past 5 years. That list includes Facebook, Instagram, X, which used to be called Twitter, TikTok, YouTube, LinkedIn, and several others. This is not optional. This is not a field you can leave blank if you use social media. Providing false information on a U.S. visa application is a federal offense and can result in a permanent bar from the United States under INA 212A 6C, which covers misrepresentation and fraud. So the trap is real on both ends. What you have posted can be used against you, and failing to disclose the accounts where you posted it can also be used against you. But here is the catch that most people are completely missing. The disclosure requirement is just the beginning. Officers are not simply glancing at your public profile and moving on. There are automated systems and human reviewers working in combination to flag content, analyze patterns, identify associations, and build a picture of who you are, what you believe, who you associate with, and whether anything in your digital history creates what the government classifies as a ground of inadmissibility. And those grounds are broader than most people realize. Let us talk about the specific categories of content that are creating real problems for real applicants right now. The first is evidence of unauthorized work or intent to work without authorization. If you are applying for a tourist visa and your Instagram shows you doing freelance work, selling products, offering services, Or if your LinkedIn profile lists employment at a U.S. company during a period when you were in the United States on a visa that did not authorize employment, a consular officer reviewing that information has grounds to question your application and potentially deny it under INA 212A 5, which covers labor certification issues, or to find that you misrepresented your purpose of travel. People lose B1 and B2 visa applications over this more than almost any other social media issue. The second category is expressed intent to overstay or abandon your home country. One of the core requirements for most non-immigrant visas is that you demonstrate strong ties to your home country and a clear intention to return after your authorized stay. If your social media history shows posts about wanting to stay in the United States permanently, about how you never want to go back home, about your plans to find a way to stay regardless of your visa status, even if those posts were made casually, even if they were made years ago, a consular officer can and does use that as evidence that you lack the required non-immigrant intent. This is one of the most common and most devastating ways social media content leads to denial. This is where it gets critical for anyone preparing for a visa interview or a green card consular appointment. The third category is the most serious, and it carries consequences that go far beyond a single denied application. That category is content that suggests association with, support for, or membership in organizations or ideologies that the U.S. government designates as terrorist, extremist, or dangerous. Under INA 212A 3, which covers security and related grounds, a finding in this area does not just deny your current application. It can result in a permanent bar, it can trigger further investigation, and in some cases, it can lead to consequences for family members whose applications are linked to yours. Officers are looking at pages you follow, groups you are a member of, content you have shared or liked, and comments you have made. They are looking at who follows you and who you follow. The network analysis component of this vetting is more sophisticated than most people imagine. Now, let me tell you about someone whose story reflects what thousands of applicants face every year. Let us call him David. David is a 28-year-old software engineer from West Africa who had been working toward an H-1B visa, sponsored by a U.S. technology company. He went through the entire process, the lottery, the petition, the approval, and was scheduled for his consular interview at the U.S. Embassy in his home country. David was confident. His paperwork was clean, his employer was legitimate, his salary was well above the required threshold. What David had not thought about was his Twitter account from 4 years earlier, when he was a university student and was very vocal on social media about political movements in his region. Some of what he posted was pointed, some of it was angry, and some of it referenced organizations that, in the intervening years, had been designated by the U.S. government as entities of concern. David had not thought about those posts in years. He did not connect them to his visa application. He disclosed his Twitter handle on the DS-160 because he knew he had to, and he walked into that interview believing his case was solid. The consular officer asked him directly about specific posts. David was flustered, unprepared, and his answers were inconsistent. His visa was denied under INA 212A 3. His employer had to restart the process, the petition had to be refiled, and David lost more than a year of professional opportunity, not because he was dangerous, but because he was unprepared. David's story leads us directly into the action plan, because preparation is everything in this environment. Step 1 is to conduct a full personal social media audit before you file anything or schedule any interview. Go through every platform you use or have used in the past 5 years. Read your own posts, the way a federal officer who does not know you and does not have context would read them. Look for anything that could be interpreted as evidence of intent to work without authorization, intent to overstay, support for extremist content, or misrepresentation of your activities or whereabouts. This audit needs to be honest and it needs to be thorough. Do not just look at your public posts. Look at your comments on other people's content, the groups you belong to, the pages you follow, and the accounts you interact with most frequently. Step 2, and this is critical, do not engage in a last-minute deletion spree. This is one of the most damaging mistakes applicants make, and it is one that consular officers are specifically trained to look for. When you delete large volumes of content shortly before an interview or shortly after submitting an application, And officers have access to archived or cached versions of that content through the tools available to them. The deletion itself becomes a red flag. It signals consciousness of guilt. It suggests you knew the content was problematic and attempted to conceal it. That is treated as a form of misrepresentation and can be far more damaging than the underlying content would have been if left in place and addressed honestly. If you have content that genuinely concerns you, the conversation about what to do with it needs to happen with a licensed immigration attorney, not in a panic the night before your interview. Step 3 is to prepare honest, consistent, and contextualized answers for anything in your social media history that an officer might raise. Officers are not always looking to deny you. Sometimes they are looking to understand. If you have a post that looks problematic out of context, having a clear, calm, truthful explanation of the context, what was happening in your country at the time, what you meant, why the framing looks different than the reality, can make a significant difference. Inconsistency and evasion are what destroy credibility in an interview. Honest, prepared explanation preserves it. Looking at the broader landscape of where this policy is heading, the trajectory is unmistakably toward more vetting, not less. DHS has been expanding its social media screening infrastructure, and there are active proposals to extend mandatory disclosure requirements to additional platforms and to longer look-back periods beyond 5 years. CBP officers at the border already have wide authority to review the contents of your device and your social media accounts when you present for entry, and that authority has been exercised with increasing frequency. The legal framework supporting all of this is well established and has survived court challenges. For applicants in 2026 and beyond, the digital dimension of your immigration case is not secondary. It is primary. The fundamental shift you need to internalize is this: your social media history is now part of your immigration record. It always was, in a sense. Everything you put on the internet exists somewhere. But now the systems to access it, analyze it, and use it in adjudications are mature, funded, and fully operational. The applicants who succeed in this environment are not the ones who hide. They are the ones who prepare, who audit honestly, who work with qualified professionals, and who walk into every interview knowing exactly what is in their own digital history and how to address it truthfully. If you want accurate, fast, and reliable immigration updates, subscribe to Immigration Path USA right now and turn on notifications. Immigration policy is changing rapidly, and staying informed is no longer optional. It is essential